With that, it is my pleasure to start the August 21st, 2025 meeting of the Management Labor Advisory Committee, or MLAC meeting. I am the co-chair for the management side, Patrick Priest, and we'll start the meeting as we have for the last couple of years now with an affirmation. We would like to thank everyone for their time, effort, and participation in our work before us today. We want to recognize that it is very difficult and important work, and we appreciate and value the perspectives and professionalism that everyone brings here today. Thank you. And with that, I'll turn it over to you, Administrator Watson, to do a roll call.
All right, Sarah Merrick. Is she here? I haven't seen her log in. Okay, let's go on. Sarah Duckwall.
Present. I do have to exit about 11 a.m.
Okay, thank you. Co-chair Strickland.
Present by video.
Ryan Hearn. Do not see Ryan. We'll wait and see. Margaret Waddell.
I'm here.
Morning, Margaret.
Morning.
Stacy Llewellyn.
Present.
Good morning. Lauren Bowling.
Present.
Good morning, Lauren. Co-chair Priest.
Present.
We know is here. Emily Cronin.
Present by video.
Good morning, Emily. Kim Schlesinger.
Present.
Good morning, Kim.
Morning.
And interim director Sean O'Day is not with us today. Okay, we have a quorum.
All right, well, thank you. And I do want it to be noted that Ryan Hearn did sign in after you called his name in the roll call.
Okay, all right. Good morning, Ryan.
Thank you. Present.
All right, well, thank you. All right, thank you for that. And then first item on our agenda is for public comment. There's none scheduled that I know about. And so I just open it up to, I don't think if there's anyone in the room, please raise your hand and make yourself known. I don't think there is. Or anyone online, please indicate whether you have any public comment to share. All right, well, hearing none, we will move forward. The next item on the agenda is to review the minutes of the June 6th meeting. I did receive a message from a committee member just before this that they would like a little more time to review them. And so I would ask that they be moved forward to the next meeting unless there's objections from the group. All right. And I guess there's nothing holding us back from making comments if there are any other changes that maybe before this person gets a chance to review them, they could have benefit of. Any other thoughts, edits for the minutes? All right, well, hearing none, we will bring that to our next meeting.
Co-chair Priest, is it okay if we move those to the October 2nd meeting? We have our offsite meeting at the September 15th. Does that work for everyone?
It's fine with me. Fine with me. Is everybody okay? I know nobody seems upset, so we'll do that.
Okay, thank you.
The department updates is next on our agenda, and we are welcoming Autumn Blake for Workers' Compensation Board updates.
Strickland and members of the committee, the board does not have any updates today.
Okay. All right. Well, thank you for attending. There are 2 bullet points under the Workers' Compensation Board updates. Are those something also being moved to a future meeting, or is there someone else presenting those?
Co-chair Priest, those were just the Workers' Comp Board report from April to June 2025. And the Workers' Comp Board newsletter, June and July 2025. And I just wanted you to have that information. It's also available on the MLAC website. And Autumn, will Lauren be available at the October 2nd meeting? Do you know? I guess it's a ways out there, but probably.
I'm not sure, but if you need her here, I can make sure that she attends.
Okay, that would be great. Okay,
And we should have a new quarterly report for you by then as well.
okay. Thank you.
Okay. So the materials were included in our handouts. Did anybody have a chance to review and have questions on any of it? We can share that with our future presenter. Okay, all right, well, hearing none, we'll move forward to workers' comp division updates from Terry Watson.
Yes, so I did send out, I know you like to have the MLAC 2026 calendar early. So I did email that out. We do have a short session next year, and you'll see the weekly meetings beginning February 5th and running through March 5th. That's ironic. And the short session lasts from February 2nd through March 9th. We do have a little bit of news, and for that, I'm going to hand it over to Administrator West to talk about that. So let's go ahead and have some news, okay?
Yeah, thanks, Terry. Good morning, everybody. Matt West, Administrator, Workers' Compensation Division. As we're planning the meetings for the next calendar year, you know, I know the committee likes to have in-person meetings ever so often. We just found out recently that we are going to be vacating the Labor and Industries building next year. It's due for a retrofit and a complete remodel, and that was part of it was in the capital construction bill this last session, and since that passed, there's funding available for that. So we will be moving to the Department of Revenue building, not far from here, just across the street, really. The tentative timeline for that move is March of 2026, and we're unclear what that space looks like. I would imagine the Department of Revenue has conference rooms available that we could host an in-person MLAC meeting, but we didn't want to pencil anything in as far as in-person until we have more information what that building space looks like and what the best room would be and what works for your schedule. So and then what we've been told by DAS is it's about a 3-year remodel, so we would be there till 2029 at some, and then we would move back to the Labor and Industries building. And apparently the Department of Revenue is going to be our roommates. They're going to be in the L&I building with us on a permanent basis. I think I don't know what they're going to do with the Department of Revenue building, but that's the news that we just got last week. So happy to answer any questions. Just wanted to put that out there as far as kind of why we don't have any in-person meetings penciled in on the calendar yet.
My recollection is that we wanted to shoot for quarterly in-person meetings, but I don't think there's any requirement for it. I mean, I would encourage us to have them at some point when you're able.
Yeah, we should be able to accommodate that over there. We're just unclear exactly where that would be, but when we have that, we'll share it and make sure we get those. I agree. I like the quarterly in person. I'm not a member of the committee, but I like seeing y'all.
Okay, all right, well, good. That's nice.
And then I'll just add one other, just unrelated, but while we're doing department updates, just an update on the DCBS director recruitment. Tuesday, there were 2 panels, interviews that were down to 2 candidates, our current deputy director and acting DCBS director, Sean O'Day, and then our building codes administrator, Alana Cox. And there was an external, I sent the invite to the committee, not sure if you were able to attend, but there was an external Q&A meet and greet type meeting on Tuesday. And then there was one for DCBS employees. Our understanding of the next steps is that both candidates will be meeting with the governor's office, and then a decision will be made in the near future. Don't have a date, but hopefully by the next MLAC meeting, we have a permanent director.
Okay. Thank you for that update or those updates. And Was the calendar included in our meeting materials, Terry, or it wasn't?
Yes, I believe that it was, yeah. So I just wanted to ask if everybody's okay with the calendar. We will send out the meeting invites for the next year. I just wanted to give it to everybody, have them take a look at it, and if you're good with it, then we'll send out the meeting invites, so you can put them on your calendars.
Did anybody have any dates that they would like to call out as being a conflict? I have to pull it up myself, and I apologize, Terry, and I can follow up with you after the meeting.
Okay, that
To
works.
give you any conflicts that I may have.
Okay.
All right. Anyone else?
Are we saying that the calendar was in the email for the 21st, like this meeting today? Because I'm not seeing it.
Yeah,
Yeah, I
I
agree, Emily. I've been
Oh, you're
searching,
not
so I
seeing
can't find
it?
it.
Oh, I apologize. It's on the screen right now. I thought I sent it
Okay.
out.
I thought it was operator error, so I figured I'd ask.
Oh,
Okay.
no.
Yeah, I didn't see it, but it is posted on the meeting materials for today in a PDF form. So I just pulled that up on the MLAC website.
Got it.
Yes,
Okay.
it is on the MLAC website. My error. Okay, so we don't have to make a decision. I'll email it out after this meeting, and if you have any issues, let me know, okay?
And then, yeah, we'll let you know. And do we vote on this, or it's just something, just a
Yeah, we don't need to vote on it. It's just more for your information and getting it on your calendars ahead of time.
I see one conflict, and I'll email you about it. So.
Okay.
Yeah, I'd recommend maybe the caucuses take a look at it and then get in touch with the respective co-chairs, and then the co-chairs can just get in touch with Terry. So that kind of streamlines the communications.
Good. That
Okay.
sounds like a good idea.
Okay, great. All right. So the next thing that we have is the offsite. Oh, I'm sorry. Co-chair, go ahead.
No, that's fine. We're still under your report, and
Okay.
please tell us about our offsite meeting. I'm dying to hear more about it.
Okay, so one thing I did want to let people know, the members that will be spending the night, I'm gonna send out an email to those members. We have the travel form, the TEDS form, and we're gonna try to get those filled out ahead of time. That way, when you come to the meeting that day on September 15th, we'll have it all filled out for you. That way, all you have to do is sign it that day, and then we can take it back and get it processed right away. So just, I'll send, an email is coming out, and it'll be all taken care of. So just wanted to let you know about the email that will be coming out about the overnight stay. The next thing Administrator West wanted to talk about was the format of the town hall meeting.
Yeah, thanks, Terry. So the logistics, this is or just right after the first day of the OSHA conference that's happening there in Central Oregon. Terry and I plan to be there during the day with a booth, trying to encourage folks to attend the MLAC meeting. Terry's done a lot of work on the logistical piece, so thank you to her and our partners in OSHA for allowing us to crash the conference and host the meeting there. So yeah, we just wanted to get kind of what your thoughts are. A couple of ideas we had tossed around in the past was like a town hall type format. If the committee is interested, we could, or someone on the committee we could give an MLAC overview, kind of what MLAC is, what the purpose is. I don't know, as much as we're all involved in MLAC and want to think that everybody knows what it is. There's probably a lot of people that don't even know what MLAC is. So if we want to give kind of a brief overview, the purpose, and then kind of the purpose of why we're in Bend. I would be happy to give that. We could, or if someone on the committee would like to do that. I don't need to control things or be the one. And then after that, if you want to, if each of you wants to introduce yourself, talk a little bit about your interest and why you're on the committee, and then unclear, do we want to open it up to like a Q&A? Do you want to end it and just kind of have a social or both? we just kind of wanted to hear your thoughts, and then we can work on putting that plan into action.
Did anybody have thoughts? I have a couple, but I don't see hands raised and everybody's firmly on mute. So I guess I'll go first. So I would say that it makes sense to talk about the history of MLAC and the background, and you know, selfishly, yes, please do it. I don't know, unless somebody else really wants to do it. And I don't know, introducing us, you know, Scott and I presented to SAFE, and I thought the format of that, where it was kind of a Q&A, where it was really to elicit a little about us, what we bring to the work. And I don't know, I thought that was a fine model. It was probably a little longer than you're intending, but it might be helpful to maybe do a little Q&A with the members of the panel. I would like to think there are going to be people there that have questions to ask us, but after our last time being out in the field, I'm skeptical. So I don't know. I think leaving room for it, but I've never been to this conference. I don't know. Do you feel like there'll be a lot of people there and a lot of interest, or I don't really have a sense for that.
Yeah, and I've attended, and they're, you know, it's a safety and health professionals. This particular conference, excuse me, I think has a construction focus. So we anticipate a lot of people in the construction industry. I would imagine they're very familiar with workers' compensation, and so we could, you know, we could have some questions to prompt if we're wanting to, if the committee's wanting to know their experience, their pain points, systematic things that they would like to see looked into. If that, we could sort of have an open forum and ask those questions. If there are certain questions ahead of time, you know, Terry and I, as we're talking to people at the conference, we could prompt them, hey, start thinking about this. This would be a good opportunity for you to ask these types of questions. It really can be whatever you all would like it to be.
All right. Well, thank you. I see Scott Strickland has his hand raised.
Yeah, I like kind of everything that's been discussed. I wonder if we do a kind of, as Patrick mentioned, the presentation that we gave for SAFE was a sort of what is MLAC, what is the system in Oregon, and what makes it unique. Just a brief overview, kind of contextualizing who we are, why we're there. And I, again, would happily volunteer Administrator West to, or second Matt, Administrator West volunteering of himself to do that and kind of provide the context and what MLAC does and the members and the tiny snippet of the history, maybe, 10 minutes or so, nothing too comprehensive. And then I think kind of a Q&A with the members individually, I think would be helpful too, to get that kind of perspective of, okay, so here's what MLAC is meant to be and was created, and then here's how we're kind of achieving that currently with the different perspectives from the different industries and different groups, with a bit of a Q&A just so folks get some background. And then I think it would be great to have that sort of open and maybe have a few questions ready to go, but sort of just a, open, here to listen to concerns or thoughts or feedback, positive, always too, from folks, see what we get. If there's not really any response initially, having some kind of guided questions for targeting things to engage stakeholders, I think would be a great idea.
And I see Ryan Hearn has his hand. Thank you, Scott. Those are great comments.
Yeah, thank you, Co-Chair Priest. My thought was if we could maybe include our work plan, the things that we've accomplished this year, things that we're working towards, so they kind of have an idea of, where our focus is. You could even go back and maybe identify, previous things that MLAC committee members have done in the past for the system, maybe highlight some of those big moves that we've done as a group. Yeah, I think that would be good.
That's a good idea. Thank you. Thank you, Ryan. I see Sarah Duckwall also has her hand raised.
Thank you, Co-Chair Priest. I agree with all of the thoughts presented. And I like the idea of having some canned questions ready, so we can engage in that format if no one is raising their hand. I do want to note that some of us will be online and remote, so just think about how you want to interact with the in-person format with the online as well.
Okay, good point. Will we have that capability in the room where we're at? We'll be, okay, good, good. I'm
Yes.
happy to hear that. I'm glad you can participate virtually, Sarah. Any other comments?
Co-chair, I'd just like to add that I've invited all the elected officials, legislative representatives and senators. I've only heard back from Senator Lithicum, and she said she's not able to make it. So I'm hopeful that they'll all be there. We'll have local officials too, is my hope, so.
Okay. All right, sounds good. So the conference itself, like who are the main participants you said are for the construction trades is the purpose of the event? It said, I thought it was OSHA, that maybe seems more general to me, but do we want to reach out to some of the like the exhibitors or maybe the main, the organizations that have the most attendees?
So, do you want me to take this or you want to take it?
Sure, either.
So when I talked to Cheryl Lean, who is the Oregon Ocean Conference Coordinator, their conferences are in coordination with the ASSP, the American Safety.
SSE?
Oh, it changed. Yeah. The Safety Professionals is what that acronym stands for. So it could be construction, it could be your safety and health people, it could be your HR people, it could be construction, but it could be also city and county people that attend these the Central Oregon Safety and Health Conference. So it could be a vast amount of people. And Cheryl is going to send an email out to all the registrants. Is that a word? People that are attending the conference. And let them know about the MLAC meeting. And then Matt is going to make an announcement at lunch that day, and let them know that we're having an MLAC meeting. And please come see Matt and Terry at booth 123, whatever it is, and they can give you more information about the MLAC meeting. So I think we're doing a good job of sharing the information so that we'll have people at the MLAC meeting. We'll have lots of folks.
Sounds good. All right, well, thank you. Scott Strickland has his hand raised again.
Yeah, I was gonna say in that outreach communication, I know maybe a link, there's that video of sort of what MLAC is on the landing page, but then also the link to that wonderful how to bring a concept to MLAC or present a concept. I think that might be helpful just to kind of, spread that info out. WCD did such a good work on that. I think it'd be great to have that disseminated further.
Good. All right, anything else? Ryan Hearn.
Thank you, Co-Chair Priest. Just a quick question. Will the MLAC members who are there in person have access to go to the conference, or is that separate?
That's separate.
Yeah, I figured it.
Sorry.
No, it's okay. It was a hope.
Registration's open, Ryan, if you want to sign up.
Absolutely. Thank you, Terry.
You can come hang at the booth with Terry and myself.
There you go. There you go. Sneak in.
Oh, great. That was a good question. Well, it seems like it kind of fits with our charge, right? A lot of the work that they do, a lot of the presentations overlap with workers' compensation, I would think. So, all right, well, good. Did you administrators get the information you needed from us about to move forward? Okay, good.
Yes.
Thank you for all your coordination.
Thank you. Was hoping somebody else jumped in and was like, I want to be the one to present, but it's okay.
Yeah. Sorry. All right. Well, do you have any other division updates?
No, sorry. Yeah, we're good.
Okay, good, good. All right. So the next item on the agenda is a presentation. It is a presentation on the history of exclusive remedy, and it's from policy analyst Aaron Feldman.
Yes, good morning, everyone. My name is Aaron Fellman. I'm a policy analyst with the division. You may remember me from your review of HB 2800 last session. And I am here today to talk about the history and some of the present of exclusive remedy. To give you a sense of the agenda, I'm going to start with some basic workers' comp history because it provides some useful context for this topic. Then I'm going to take you through the protections provided by exclusive remedy under current law and the exceptions to those protections. I'll break for questions at the end. Please also feel free to interrupt me as we go along. This presentation is going to be about 15 to 20 minutes. Next slide, please. So a good place to start is before compulsory workers' compensation laws, litigation over workplace injuries was much more common. In many cases, this would be the only way an injured worker could access compensation after being hurt on the job. These lawsuits hinged on the question of who was at fault for an injury. To prevail, an injured worker needed to demonstrate to a jury that their employer's negligence had led to them being hurt. The employer might defend itself by arguing that the worker or a coworker were more to blame, or that the worker had assumed the risk of injury voluntarily. The status quo had serious disadvantages for both parties. Most obviously, it was bad for workers because they had no guarantee that they would ever be made whole, even if they had the resources to go to court, which would have been out of reach for many. But it also had disadvantages for employers because defending lawsuits is costly and acrimonious, and jury awards are unpredictable. Next slide, please. Workers' compensation was designed as a no-fault system with this history in mind. By a no-fault system, I mean a system in which an injured worker can access benefits without having to prove that their employer was negligent. The worker can't be denied benefits on the basis that they themselves were negligent. And these benefits are the worker's exclusive remedy for workplace injury. In other words, the employer can't be held liable for additional compensation, whether on the basis of negligence or otherwise. Next slide, please. To give you a sense of how foundational this principle is to the system, this is the exclusive remedy provision of Oregon's original 1914 workers' compensation law. The 1914 system was almost unrecognizable by today's standards. For starters, the state was at that time the sole provider of coverage, and only employers in what were called hazardous occupations were required to participate. But this principle of exclusive remedy was embedded in it from the beginning as part of the original grand bargain between labor and management. The 1914 law was signed by Governor Oswald West. The portrait you see here was out of public eye for many years before being discovered by then Secretary of State Norma Paulus in a tunnel under the Oregon State Hospital. This is going to be a very wordy presentation, so I'm going to be sprinkling these art history interludes throughout to add a little bit of visual interest. Next slide, please. In 1965, the legislature passed HB 1001, which overhauled the 1914 law and laid the groundwork for Oregon's modern workers' compensation system in a lot of ways. HB 1001 was signed into law by Governor Hatfield, who doesn't have a portrait in the Capitol, but does have a bust. A fun fact, this is carved from Vermont marble left over from the 1977 expansion of the Capitol. This is the stone that was used to face the new wings. To the right of Governor Hatfield is subsection 1 of the exclusive remedy provision as adopted by HB 1001. We're going to take a deep dive into the current law in a second, but I wanted to show you this first to illustrate how little the exclusive remedy provision has actually changed since 1965. In fact, the statute has only been substantively amended about 7 times in the past 60 years. For comparison, ORS 656262, which is a claims handling statute, has been amended more than 35 times. So I think it's fair to say that this has historically been a fairly static area of the law, though there have been some significant changes which we'll discuss. Next slide, please. Now that you have a sense of some of the history of exclusive remedy in Oregon, we're going to take a look at the current law, ORS 65618. I'm going to start by talking about who is immune from suit under the statute, but please do bear in mind that there are exceptions to this immunity, which I'll cover a little later in the presentation. I also want to offer a quick disclaimer and an apology at this point. The disclaimer is that DCBS doesn't play a role in litigation over whether exclusive remedy bars an action against an employer in any particular case. This is an area of the law that we have an interest in, but we generally operate at one remove from it. So if you want to get into the weeds with your questions, that's totally fine. I'm happy in the weeds, but I may have to take some time to research and get back to you. The apology is that, as I mentioned earlier, this is a wordy presentation and it is only going to get worse from here on out. So please bear with me and thank you in advance for your patience. Next slide, please. All right, what you see on the screen here are subsections 1 and 2 of ORS 65618. These subsections are the meat of the statute. They lay out what most people think of when they think of exclusive remedy. And they sort of operate as two sides of the same coin. Subsection 1, the employer side, provides that an employer's liability under ORS Chapter 656 is in place of all other liability, specifically including liability towards third parties under an indemnification agreement, which we'll talk a little bit more about later. Subsection 2 provides that a worker's rights under this chapter are in place of any other remedies they might have under law, common law, or statute, which is pretty broad. What these subsections mean in practice is that as long as an employer meets its obligation to provide workers' compensation coverage, thus assuring that workers and their beneficiaries will receive the benefits they're entitled to under the chapter, those workers and beneficiaries can't bring civil suits against the employer. Next slide, please. Subsection 3 extends exclusive remedy protections to the employer's other workers and to certain responsible parties such as officers and directors. An injured worker can't recover from one of these parties either, even if they think that they had some responsibility for the accident. The worker also can't recover from DCBS, their employer's insurer, claims administrator, or their employers and responsible parties. For example, in a suit over claims handling matters. The worker does have a right to dispute a claims handling decision, of course, but they have to follow the process laid out in Chapter 656 to do so. They can't deviate from this process by taking one of these parties to civil court. Next slide, please. Subsections 4 and 5 extend exclusive remedy to worker leasing companies, temporary service providers, and their clients. Excuse me. We talked about this a little in the discussions around HB 2800, but essentially these sections are there to clarify how exclusive remedy applies in these kinds of multi-party employment relationships. These subsections became law during the administration of Governor Roberts, seen here. This portrait was painted by Portland artist Amy Erickson, who still lives and works in the city. I'm sorry, was there a question?
I don't have one. I don't know if, I don't see any hands raised.
Oh, I'm sorry. I thought that I heard a noise, but maybe that was from a different room. Where was I? Oh, yes. Next slide, please. Subsection 7 provides that a worker, or I'm sorry, that an employer is entitled to exclusive remedy protections for workplace injuries, even if those injuries are found to be non-compensable. This most obviously arises in the context of claims denied on major contributing cause grounds, but it could come up for other kinds of claims as well. This language came out of the 1995 HB 369 reforms, signed into law by Governor Kitzhaber in his first term. This was probably the biggest single change to exclusive remedy since '65, and it was immediately controversial. Later on, we'll talk about the state of the case law after the dust settled on this one, but there's a few other things that I'd like to cover first. Next slide, please. Now that we've talked about the contours of the protections offered by exclusive remedy, let's talk about the exceptions. First and most obviously, non-complying employers are not entitled to exclusive remedy under ORS 65620. In fact, if the injured worker of a non-complying employer brings an action for damages, the employer is denied certain defenses, such as attributing the injury to the negligence of the claimant or the negligence of coworker. You may remember these from earlier as defenses that were often raised before the era of compulsory workers' comp. In general, 65620 operates to take an employer back to before those laws were passed, but it goes further than that by limiting defenses that would have been available at that time. Next slide, please. If a third party, someone who is not the employer or fellow worker, was responsible for causing an injury, the injured worker can bring an action against them under ORS 656-154. So for instance, if you're injured in a motor vehicle accident, you can generally bring suit against the other driver. ORS Chapter 656 does contain some procedural rules for these suits. If the worker doesn't want to bring an action, the employer's insurer can bring it on their behalf, and the insurer is entitled to a portion of the recovery either way to compensate them for the benefits that they paid. And the statutes there are 656, 580, and 583. So you could call this a semi-exception or a qualified exception. It provides a means of recovering benefits beyond what the chapter ordinarily allows for, but it doesn't create any additional liability for the employer. This includes liability under an indemnification agreement because ORS 656-18 sub 1 generally voids such agreements. Next slide, please. A responsible person or coworker can be sued over an injury brought about by their willful and unprovoked aggression. So if you're assaulted in the workplace by a coworker, for instance, exclusive remedy does not shield that person from liability. Courts have sometimes interpreted aggression to include acts that didn't involve physical force. A notable example of this is in Palmer v. Weimar, 1988, in which the Court of Appeals found that a worker could bring a sexual harassment suit against her supervisor under this exception, even though she also had an accepted workers' compensation claim for mental stress stemming from harassment. Next slide, please. An employer isn't entitled to exclusive remedy for an injury that they deliberately intended to cause. And this is 656-156 sub 2. One point of contention about this exception is whether a jury can infer an intent to injure from an employer's failure to maintain a safe workplace. Courts have sometimes remanded cases on this point for consideration of that issue. For instance, in Kilminster v. Day, 1996, which involved a worker who was killed in a fall from a communications pylon and whose employer had not provided a safety harness. On the other hand, courts have also said that an employer is entitled to immunity when the plaintiff concedes that lax safety practices were motivated by a desire to save money rather than an affirmative desire to injure workers. And that's Davis v. U.S. Employers Council. There's only one case that I'm aware of where appeals courts have ratified a finding of liability under this exception, and that's the 1934 case of Vice v. Allen. This is kind of an unusual fact pattern. The claimant in this case was injured by a spring-operated gun his employer had hidden in the workplace to deter burglars. The court found that the employer had obviously intended to injure someone and wasn't entitled to exclusive remedy just because he hadn't intended to injure that worker specifically. And I mention this as an illustration of how high the bar to overcome immunity under this exception has historically been. Next slide, please. There is one case where an employer's safety practices can void exclusive remedy without demonstrating an intent to harm. And that is if the injury resulted from a failure to comply with an Oregon OSHA red warning notice. A red warning notice is a posted order shutting down a workplace or piece of equipment until safety issues are remedied. If you order a worker to return to work in defiance of one of these orders and the worker is hurt, they do generally have a right to bring an action against you. This exception was signed into law by Governor Straub, the only governor whose portrait includes a dog. The dog's name is Shadrach, and that's going to be on the test, so write it down. Next slide, please. Persons otherwise immune under 656-18 can be sued over negligent acts outside the capacity in which they qualify for immunity. So just to throw out an example, if you're a delivery driver and you get into an accident with your supervisor while they are driving their personal car, you would generally have the option of bringing a suit for negligence. Your supervisor would ordinarily be immune from suit as a co-employee, but they're not immune if they're acting outside that capacity when the injury happens. One qualification here is that acts in a dual capacity may still be immune. An important piece of case law on this point is Nancy Doty versus Wildcat Haven, which involved a defendant who was a corporate officer of the claimant's employer, but who also owned the land in which the employer operated. The court found that the defendant couldn't be sued for her actions as a landowner because they were conducted in her dual and immune capacity as corporate officer. Next slide, please. I want to close out by mentioning one non-exception, and this brings us back to something we talked about earlier. As we discussed, ORS 656-18-7 provides that employers are entitled to exclusive remedy protections for workplace injuries, even when those injuries are found not to be compensable. But a related statute, 656-19, provides that workers may pursue civil actions for these injuries, at least those denied for failure to meet the major contributing cause standard, only after an order affirming the denial has become final. So we have one part of the law that says that employers are immune to suit over work-related but non-compensable claims, and another that says workers can bring suits after denial becomes final. How do we reconcile these provisions? To do so, we're going to need to take a look at the somewhat tangled history of this issue. Next slide, please. ORS 656-18-7 became law in 1995, and it very quickly wound up before the courts. In 2001, the Oregon Supreme Court found it unconstitutional, at least situationally, under the remedy clause of the Oregon Constitution. And that's in a case called Smothers v. Gresham Transfer, Inc. The remedy clause provides that every man shall have remedy by due course of law for injury done him in his person, property, or reputation. And the court found basically that exempting an employer from liability outside the chapter for an injury that is not compensable under the chapter violated that principle. In response to that ruling, the legislature enacted 656-19, providing that a worker could only pursue a civil action under Smothers after the denial of their workers' compensation claim had become final. But about 15 years later, the Oregon Supreme Court overruled Smothers in the case of Horton v. OHSU. However, ORS 656-19 remained on the books, which led to the question of whether the legislature, in enacting that law, had created an exception to exclusive remedy that remained in force post-Horton. The Supreme Court finally resolved that question just a few years ago in 2023 in Bundy v. Newstar. What they found in that case was that 656-19 was not an exception to exclusive remedy. Essentially, they found that the statute was procedural. The legislature put it in place to govern actions under Smothers, but it didn't codify Smothers. And once Smothers went away, 656-18 sub 7's grant of immunity for work-related but non-compensable claims was back in force. ORS 656-19 still operates to require claimants to wait for a denial to become final before pursuing a civil action. But because it doesn't void an employer's immunity, such a suit would be an uphill climb. I hope that's clear. I suspect it is not. But next slide, please. I'm going to leave you with this portrait of Governor Tom McCall, not because he signed any bills related to exclusive remedy, but just because it's a fun painting. As you can see, the governor is standing on a beach in sort of a dynamic pose, his suit billowing in the wind as a helicopter goes by in the background. There's just a lot going on here. I really encourage you to go see this one in person when the Capitol reopens. It's really something. And with that, I will close out the presentation and open it up to questions.
All right. Thank you very much for that very good presentation. A lot of words, but you got it across really well. So I just want to compliment you on that. And I see a question from Margaret with that.
Right. I was just wondering if you could explain if Oregon's approach to the exceptions to exclusive remedy are similar to like California and Washington, or if they have other kinds of exceptions, like, for example, gross negligence.
That's a great question. I don't have an immediate answer for you, but I'd be happy to do some research and get back to you.
Thank you. Scott Strickland has a question.
More a comment. unrelated to this, but related to that lovely portrait of Governor McCall. Interesting, the symbolism on that as well, with the helicopter and the marker out in the water, referring to the state ownership of public beaches, that recently became interesting in the offshore wind field, where we got a lesson on Dane law and other ancient laws that govern the property ownership within the North Sea. So just wanted to loop, since we were going down that rabbit hole, I just had to throw all that out there as well. Thank you again very much for the presentation and the art history as well that went along with it.
Yeah, thank you. Good comment. Sarah Duckwall has a comment or question.
Thank you, Co-Chair Priest. Can you speak to that? I believe, I don't remember the number of the Senate bill, if someone wants to pull that up, that was potentially before us, and how that would have,
74, I believe.
Yes.
how that would have affected exclusive remedy in this realm.
I'm gonna take that one.
Yeah.
Anybody?
Yeah, I can answer that one, or attempt to answer it. So, can't really speak to what the effect would have been. Senate Bill 174 as drafted towards the end did not have a carve out for workers' compensation. Our understanding was, that it wasn't intended to affect the exclusive remedy, and the drafters felt like it didn't. But unclear what if any impact there would have been. It would have been something that would have gone through the courts, for the courts to weigh in on if somebody brought a suit to their employer or their insurer under that bill or under that law. If it had passed, then it would have gone through the courts for the courts to determine. I know it's not helpful, but
Yeah, no, I mean, I just, with this being foundational to Oregon, exclusive remedy through workers' comp, it would be really hard to support something that carve out doesn't exist. It's just, talking, because it seems to work so well for us in a system. So that piece was just a comment, but thank you.
Thank you, Sarah. Speaking of Senate Bill 174, I don't know that we ever got, what was the resolution of that particular initiative in this last session?
Bill died.
That we could get an update on?
yeah, the bill did not move forward. It died in Terry, as Terry said.
Yeah,
Okay, so
And- yeah, I don't think I didn't receive any sort of update from anybody, so.
Yeah. I think the presentation we just received, and I learned a lot with it, was really in response to some of the comments we had in a previous meeting. I think that's why you scheduled it. And so I will do my very best to remember all of this information if it comes up again. And somebody asked for a copy of the presentation. Thank you for forwarding that along. Is it something that we should be prepared for the next session? Do we know?
I do not know, Co-Chair Priest. Again, the bill died. That's all I know at this time, and I don't know anything else at this point. And also the PowerPoint is up on the MLAC website for today's meeting. So it's there as well.
Okay, wonderful, wonderful. And that stays there for a period of time. I think we talked about that before. It's there's a retention period for our materials. Okay.
Yes.
Okay. All right. Well, thank you very. It was very, very interesting. Any other questions or comments? Ryan Hearn has one.
Yeah, I'll just say great presentation. I really appreciate all the hard work you put into that. Very educational. I learned a lot through it. So just want to reiterate that. You're a great presenter. So thank you for your time.
Thank you, much appreciated.
Yeah. All right. Well done. Well, with that, I will move forward to the next item on our agenda, which is MLAC subcommittee updates. The first one.
I think we had one quick other question, Patrick, sorry.
Sorry about that. Oh, I didn't see. Sorry, Margaret.
Well, it's just a comment. I too wanted to thank for the presentation. But I think that as a committee, while we are thinking about the evolution of the and protection of the exclusive remedy, side by side, another issue is the changes that have occurred in the compensability standard for what the relationship between the need for treatment and the workplace exposure is. So if we look at one without the other, it doesn't seem like it really gives us an overall picture of the either the protections of that the employer has or the access to care and compensation that workers might be entitled to.
Thank you for that comment. Hopefully we will be prepared if it comes around again. Hopefully it'll be soon enough that we'll remember all this stuff. So thank you, Margaret, for that. Anything else? All right, well then I think we are ready for our MLAC subcommittee updates. The first one on my agenda is access to care. And we have two co-chairs. I'm not sure which one would like to speak. If not
That
both.
would be Emily. Emily was going to give the update to access to care.
Yes, I
All right.
am.
All right.
I'm ready to do so. Thank you, Co-Chair Priest.
Yeah.
Just a quick update, and I'm happy to take any questions. So far, we've had several meetings with a wide variety of provider feedback, mostly focused on barriers within the system and their experiences treating injured workers. We've had occupational health, we've had an NP. I believe it's a surgeon that is going to be presenting for us on Friday. We are beginning to see some trends, and we're sort of now beginning to review current and relevant statutes and orient towards policy discussions. So that's sort of where we are.
Okay, well, thank you. Thank you very much for your work on that and that report. Kim, did you have anything to add as the co-chair? No? Okay.
No.
Okay, thank you. Thank you for your participation as well. All right, the next subcommittee update is for average weekly wage. And I know my co-chair Strickland is one of the chairs of that, as well as Stacy Llewellyn.
I am, and I have the update for that today.
Okay.
Similar to the access to care, we have been in the research data collecting mode. And so this meeting tomorrow, and again, I apologize if there's a lot of background noise. I'm in a public office, so apologize. But I would say that we are finishing our data collection phase of the work that the subcommittee is doing. We plan on hopefully finishing that work tomorrow. We've had several stakeholders provide various data points. Great effort from all those engaged, and we really appreciate their support. And then once we are finished collecting the data, then we plan on to switching gears into actually looking at how we can apply the information that we've collected, what that could look like for making any changes going forward to the average weekly wage, and especially focused on the low income portion of those folks. Scott, anything else you'd like to add there?
No, I think just a shout out to the analysts and researchers at WCD. That's been really helpful to have access to all the data and information and have it kind of collected in a way that's digestible to us volunteers. So thanks on that, and thank you to the stakeholders. I think we had a pretty good meeting last time with some pretty robust stakeholder engagement. Look forward to more of that and more of the kind of, as we delve into what policy could look like, so that we have a understanding of what's coming around the bend. I think would be very helpful. But thanks to Stacy and the others for all their support as well.
Yeah, absolutely. Thank you both for your report and your work on this subcommittee and all those that have contributed toward it. So I look forward to the results. With that, I think the next item is just a reminder about our upcoming meetings. I'll turn it over to Administrator Watson for anything she would like to share on those.
Yes, we have our September 15th in-person meeting at the River House Conference Center in Bend, Oregon, and then back to virtual meeting on October 2nd. And that's when the subcommittees will come back with their recommendations on October 2nd.
Okay, wonderful. All right, there are no other items on the agenda. Is there anything else you would like to bring forward? Nothing else? Okay. Well, since we're ending quite a bit earlier than the scheduled time, I will ask for a motion to adjourn the meeting.
So
I'll move.
moved.
In a second.
All right. Sarah seconded, Stacy made the motion, I think. And all those in favor signify by saying aye.
Aye.
Bye.
Are there any opposed? Same sign. Okay, hearing none, the meeting is adjourned. Thank you very much, everyone.
Thank
Bye-bye.
you.
Good to see you all.
You too.